Welcome back to Land Investing 101, where I teach you guys legal jargon in reference to real estate and land investing, as well as land investing tips, land investing practices, and even some vacant land for sale from my holding company. So today we're going to talk about concurrent estates. Concurrent estates, and I have some notes here so I don't miss anything. Concurrent estates includes tenancies in common, joint tenancy, and tenancy by the entirety. So what are concurrent estates? Concurrent estates allow multiple parties to have estates or interest in land or real estate at the same time. So this is very common in a rental situation when somebody is renting a house that another person owns. They both have an interest in that property, right? The tenant has an interest in the property to stay there for a certain amount of time and for a certain benefit, whether it's commercial or residential, and the landlord has a right to the actual real estate, meaning he can mortgage it, he can sell it, or divest from it, which is the same thing as sell it. So let's take the concurrent estates in order. First, the tenancy in common. So I'll read you what I got here. The tenancy in common is first and foremost is a concurrent estate. It forms a concurrent ownership where two or more parties have the right to possess and use property simultaneously, and each co-tenant may freely sell or transfer their share. Unless otherwise stated, when you're transferring something to two people at one time, it forms a tenancy in common. And they cannot alter the property without the permission of the other tenant. So, for example, as I talked about in the first video, there's two kinds of property. There's real property and there's personal property. So personal property would be something like a bank account, and you give it to your two children. If nothing else is stated in the conveyance, it's known as a tenancy in common. A tenancy in common. And they may, one son, if there's two sons, one son may freely use one half and sell one half of that bank account, whether it's stocks or bonds or whatever's in that bank account. So that's a tenancy in common. It forms a concurrent ownership where two or more parties have the right to possess or use property simultaneously. So if I give the property, if I give 100 acres to two of my kids as tenancy in common, which also is tenants in common, they can use the whole 100 acres. So it's not like one son has 100, one son has 50, and the other son has 50. They can use the whole 100 acres. Okay, let's move on. Joint tenancy. Joint tenancy is a type of concurrent ownership with the right of survivalship. So what does this mean? So when you give a joint tenancy, let's say I gave my two kids 100 acres in joint tenancy. When one dies, the other gets the whole property. So if I give, a lot of times husbands and wives have bank accounts or real estate in joint tenancy. This means if me and my wife have a property in joint tenancy, I die, she gets the whole property, as opposed to if we were joint tenants, as opposed to if we were holding the property as tenants in common. As tenants in common, I own half and she owns half. So if I die, half gets divested through my will. I would leave it to her by choice, but that may not always be the case. So to give you a better example, two people own properties. One owns it in, there's two different sets. One owns a piece of property, whether it's real estate or a bank account, in joint tenancy, and the other one holds it as tenants in common. A joint tenancy, and the other one holds it as tenants in common. Under joint tenancy, when one party dies, the other party gets the whole amount, right? It has what they call the right of survivorship, a type of concurrent. In tenancy in common, if one dies, they still only get half. That other half is left according to that person's will. So a right of survivorship in joint tenancy, the right of survivorship means that if one tenant dies, the share automatically goes to the other tenancy. So now, how do you form a joint tenancy? So if nothing is said in a conveyance, tenancy in common is what is assumed, meaning it's half and half, right? If you would like to create a joint tenancy, you have to have what they call the four unities, the unity of time, the unity of title, the unity of interest, and the unity of possession, which means you had to give it at the same time, it had to be transferred in the same title, It had to be an interest in the same real property, and it had to be possessed by one person when they were giving it. So those are the 4 unities, or the 4 elements of a joint tenancy. So we went over joint tenancy in common, we went over joint tenancy, we went over the elements of joint tenancy, which are unity of time, unity of title, unity of possession, and unity of interest. Basically meaning when you're conveying the property, you have to convey it at the same time to the same people, to the 2 people at the same time. It has to be an interest in the interest, meaning the real estate or the property, has to be conveyed at the same time. And the possession has to be one. So you can't be conveying something you don't own from somebody else. And then they have a third one, which was abolished in more states, which used to be called the tenancy by entirety, which would basically be the 4 elements of a joint tenancy plus marriage. So if you were married and you conveyed the title, it basically had the right of survivorship along with that. But that's been abolished, and now they have the simple joint tenancies, where you have the right of survivorship. So remember, if you're married with someone and you don't want any issues when you transfer the property to a couple or to a married couple, if you file it as a joint tenancy, when one person dies, the other person automatically gets the property, as opposed to giving it to someone as tenants in common, which means if someone dies, the other person only has half, and the other person's estate gets the rest, according to their will or according to the laws of the state. So those are concurrent estates. The biggest thing you have to remember about concurrent estates is the difference between tenancy in common, or what they call tenants in common, or joint tenancy, or joint tenants. Those are the 2 big differences. Hope this was helpful. Join us, subscribe to the channel, and check out our blog.